what is due diligence, why should we be doing it, and what is the significance of due diligence when we go and give submit an interest for purchase for investment in real estate. So this is the key topic of our today's discussion. Joining the event today, we have myself. I am Farhat Ali Khan, Managing Partner, Century Maxim from Dubai office. We will have with us Dr. Pinky Anand, the senior advocate with distinguished practice at the Supreme Court of India, and she's just recently, in July 2020, completed a 5-year term as the Additional Solicitor General of India. In fact, she's the second woman in India to have been awarded the Constitutional Law Office in India. And then we have our third speaker, Ms. Nupur Prasad. She's a practicing lawyer before the Supreme Court of India and High Court of Delhi. Nupur is a partner with Century Maxim India's office and handles legal matters, which includes family, civil, real estate, due diligence, legal metrology, labor, and other matters. She's got over 17 years of experience as a corporate, commercial, and regulatory lawyer, worked as an in-house counsel with large corporations as well. So our topic today is due diligence in real estate and the significance of RERA in India. So we proceed further on this. Now, we all know and we all understand that real estate is the biggest asset of any country. When we look at big cities like Dubai, like Mumbai, Delhi, Gurgaon, we see beautiful skylines, and we all would aspire, dream, would want to have a property owned in these beautiful skylines. So the skylines basically signify the level of development a country would have. Now, there have been instances across territories, across jurisdictions, where developments have failed because of promises which were not kept by the developers, by builders, by the promoters of real estate entities. So as we start, we proceed further. So our speakers, as I mentioned, with me is Dr. Pinky Anand. She would be joining in the next 5 minutes. Nupur is here. Now, the first question to our viewers is, if you are a victim of an incomplete real estate promise, and this could be anywhere in any part of the world, in any city, these beautiful skylines are owned by millions and millions of investors, but millions and millions of investors have actually failed to get deliveries of their premises, of their units, be it a commercial property, be it a real estate property. And real estate is such a sensitive matter where people have saved for life, invested, and when that investment goes bad, one can imagine what feeling that individual or that family or that investor would be going through, the kind of hardship that individual might have gone through. So there are some instances that we have seen in the past few years where leading developers of the NCR region or in India or Bombay, they have been arrested for fraud. They have been booked for committing a breach of trust to their investors. Now, our objective in today's webinar is that as we discuss this, it is important that we educate you that before you invest in real estate, you must do certain basic due diligence. You must do certain basic checks so that your investments are not wasted. So your life savings are not drained, just on the basis of a false promise. So we go forward and discuss this. So what topics are we covering today? Our topic is what is basically a due diligence in real estate. What is the meaning and definition of due diligence, and what is the importance, why we should be doing a due diligence in real estate. In India, we will explain, Nupur and Dr. Anand will explain the key elements of due diligence in real estate, the features of Real Estate Regulations and Development Act of 2016, what are the contours of real estate regulatory authority and the key compliances by real estate developers and certain landmark judgments where the Supreme Court and various high courts of India have outlined and given guidelines clearly in favor of the buyers, in favor of investors, and interpreted that arbitrary arguments, favoring developer is not maintainable. In UAE, UAE is a more simplified process, more organized. So in UAE, the key elements of due diligence in real estate, how the RERA functions here, what key real estate compliances are required by developers here, and what are the recent developments. So when we say due diligence in real estate, so due diligence, the word means that it is basically a verification, a survey, an investigation, or a cross-checking of property records and all else deemed relevant records related to sale, purchase, lease, or mortgage of a real estate of a property. Now, when we say due diligence, it collates, brings together all the knowledge and information that is useful for the buyer or investor to know before proceeding with an investment. So if I have to invest $100,000 in a property, so I should be doing certain basic checks before we invest in the property. So what I would be doing is I would want to know if the person who's selling me this property is the actual owner. Is the person who's selling the property has built it legally? Is the property that I'm going to buy does not violate any local laws or does not have any encumbrances on it, or does not, is a property which is not rightfully owned by the seller? So, so these are the precautionary measures to ensure that investment in a property is safe and secure. Now, it helps in assessing the right. It also helps in assessing the right value of the property and enables investor to take an informed decision. So what is the importance of due diligence in real estate? One, to start with, it analyze the potential risk and threats. So we can do a basic assessment that could there be a potential risk or threat if I intend to invest in a property. This analysis could help me prevent a fraud. It safeguards the funds being invested. So my $100,000 or in INR or dirhams is invested properly, remains secured, and my returns are not taken, my investments are not taken away by somebody else. The property that I'm buying is free from encumbrances, liens, charges, and litigations. So there should not be a situation where I buy a property, but there is a litigation going on, and 5 years later I get to know that there was there is a court order and I no longer hold the title of the property. Finally, we've seen many instances, particularly in the in many cities, where buildings which are ready have been asked to demolish or have been declared illegal by high courts or Supreme Court. There have been many cases where I invested hundreds of thousands of rupees or dollars, and I wait for an apartment, and when that apartment is ready to be delivered, we get to know that the High Court or the Supreme Court has said that this building was constructed illegally. So how do we do it in UAE? So I will just quickly explain the processes involved in UAE. So if an individual who intends to invest in a property in UAE, so what he can do is and UAE, we will take a reference of Dubai, particularly because that's the main destination of investments in real estate. If a developer has required permits and approvals, all this information could be obtained from the Dubai Land Department. and the real estate regulatory agency, which is authorized, which supervises, regulates, and monitors any selling or of real estate projects in Dubai. When we have a real estate transaction being conducted in Dubai, it is important that there is an escrow account which is managed and maintained by the developer under the supervision of the Dubai Land Department. The Dubai Land Department website will have a detailed time to time updated percentage of completion, that what level of the project has been completed and what is the expected date of completion for the project. Unlike India, I mean, here in Dubai, we don't see these kind of situations that project once ready is declared illegal by processes of court, because here the regulatory authorities and the land department are very, very strict. And once it is approved, it is assumed that there's absolutely no or very minimal possibility of the project being declared illegal. So it is important that the project that we invest is registered with the real estate regulatory agency. The developer is registered with RERA, and the ownership of the land and property is recorded with the Dubai Land Department. And one good thing, I mean, which I would like to mention here is that normally, whenever there is a builder and buyer sale purchase agreement signed, that agreement is automatically recorded with the Dubai Land Department. So like we have in India, where you just have an agreement between a developer and an investor, on 100 rupee stamp paper, and a basis which millions and millions of rupees are invested. Here, the process is that from day one, that agreement needs to be registered with Land Department. So what is the real estate regulatory agency here in UAE? So RERA is situated within the Dubai Land Department. It has and has its own financial and administrative independence with full legal authority. There have been cases where investors have gone to the RERA court and sought cancellation if there is a delay. So for example, a building is to be developed within 3 years as per the agreement, and the apartment or the unit is to be handed over, say, by 2020. And the investor is now in 2021 not handed over. The investor can go to the land department and say that I want this agreement to be cancelled, and my full money along with interest or damages or losses must be returned back. There have been cases where the RERA courts and the property courts have ordered and awarded the compensation to full, whatever investments have been made and whatever damages that are considered legally to be awarded. One fantastic thing here that we see is that every real estate agent and activity is licensed by the RERA authority. Every broker or a real estate agent, they have an ID number, and that ID number is very important when real estate transactions are signed. And all these developments are published on the government website, so the investors can study and take information accordingly. So now, what compliances should be met by real estate developers? So as an investor, if you are going to purchase a property, you must ask that all dispositions of off-plan property are registered as per law with the Dubai Land Department. So there is a provision of law under Article 3 of Law 13 of 2008, where all off-plan properties must be registered with the Dubai Land Department, as I just explained earlier. Then disposition of completed property must be registered in real property register maintained by DLD. Leases must be registered. Now, lease normally in India, when it comes to residential lease, it is not to that of significance what it comes to sale and purchase. But here in the UAE, particularly commercial transactions, on leases are very, very high valued. So the government has a clear system that every single lease must be registered with their system. The mortgages are registered with the land department. So no owner can sell you a property unless and until he's got a clearance from the bank, and that bank has given an NOC, and that NOC has been updated in the Dubai Land Department record, which will allow the property to be transferred accordingly. So, and there are certain recent developments, in the sector, where the Department of Municipal Affairs and Transport in Abu Dhabi revived a 5%. So, unlike many cities, the real estate sector is so highly regulated in the UAE that the land department and the real estate authorities, they say that no rentals will be renewed beyond a limited cap. So like Abu Dhabi, they recently introduced, because amid the current pandemic situation and the COVID that we are facing, the government said that rentals will not be, renewals of rentals will not be done, exceeding an amount of 5% escalation. So if somebody has a property rented at 100,000, the landlord cannot renew beyond, a capped rent of 105,000. There is recently, this is a big development recently in Dubai. The government of Dubai has introduced a special body, a tribunal, which has been formed, where liquidation and settlement of disputes of unfinished projects have been cancelled by RERA. So there were certain projects which have been abandoned by the developers, or the developers, being expat owners, are no longer doing business in this country. So in these circumstances, what the government has done, they've formed a special committee, a special tribunal, which will ascertain the liquidation process, which will undertake the liquidation process and ascertain the settlement of claims of each and every individual investor, or what process can be applied, or if a new investor can be if a new developer can be brought in to complete the project. So, and recently Dubai launched the REST, a digital platform which is expected to target the ease of managing all transactions related to real estate. So this is how I've been able to explain UAE. I mean, I hope I was able to clarify the process and importance of due diligence in real estate. Nupur, if you can guide us on, what could be the process in India. Dr. Anand has just joined the room, so let me just.
Yeah, let's welcome ma'am.
Dr. Anand, can you hear us?
Yes, I can. There's a slight disturbance, though.
Yeah. So no, we can hear you. It's clear. So please welcome Dr. Anand to this webinar. Dr. Anand needs no introduction. She's a distinguished lawyer practicing at the Supreme Court of India, and has recently, in July 2020, completed a 5-year term as the Additional Solicitor General of India. Dr. Anand is the second woman in India to have been awarded this high constitutional law office in India. Dr. Anand is also the Vice President of Bar Association of India. So all our licenses, So Dr. Anand, please, welcome to this webinar. We've just discussed in the past 10-15 minutes about the developments of the real estate, its importance and relevance for UAE and in general. If you can just guide us on how we can, how our audience can be alert on real estate due diligence, and what is the significance and relevance of RERA in India?
Thank you very much. My apologies for joining it late, but I had decided to travel in an earlier point of time, so I just joined in from there. But thanks, and hello, Nupur, if you are there somewhere, I think I can see you.
Yes, ma'am. Hello, how are you? And thank you so much for taking out time and joining us, even with your tight schedule. Thank you, ma'am.
Well, life is a tight schedule, but real estate is even more important. And I think, And I think the coordination between our countries, India and UAE itself, is of immense significance. And seeing the recent developments, the importance that UAE has also given to India, and of course, the kind of investments that go across borders, particularly in the private equity sector, I think it is of real interest because real estate depends a lot on the investments across the board, and India having opened up its sectors to all investments from all over the world. Definitely, it is an enterprising occasion. I must say that the real estate itself has taken its own time to develop. So before I go on to the slides, I'll just give a kind of brief rundown because I have been involved with a number of the cases that involved real estate projects, because real estate projects in India, there was a time when the Delhi Development Authority, for example, was involved with the entire process of developing, and government agencies, few private engagements, but ultimately it came into a state where the real estate started having major projects. And today you have an entire group of people who are the home buyers and people looking for not only affordable housing, but other kinds of housing, commercial housing, apartments, homestays, and other occasions where we are dealing into a number of sectors. I've also had the occasion to be with the NBCC, the National Building Project, which in fact is a government concern, and in fact recently has been the precursor and the bandwagon issue as far as India is concerned, to take over and to help a number of the projects. So having given this broad background, I know, Nupur, that you must have dealt with possibly the kind of investment that India has had, which is about a market size of USD 200 billion by 2021. And while we speak, we are in the process of going for the budget, and there are a number of expectations. So I will come with that a little later, and particularly the real estate sector, which has been looking for funding, which government in fact recently funded the last mile funding for projects, and which has given a big impetus to the real estate. This is the broad backdrop of the real estate sector in India, which we have been enlarging. And I know that from at times we find that our costing and affordability or our marking in the real estate is as high as London or Dubai is. Of course, I don't want to go into the financials at this point of time, wanting to talk about the legal part. Coming to the sectors of due diligence, Nupur, as you pointed out. Now, due diligence itself is something which is again taken a very big makeover in the legal sector. It always was there, of course, for banks and other financial institutions, but the real estate market was somewhat ad hoc about it. So I think we need to really define that timeline and define the parameters for due diligence, because it is something that requires a lot of tracing. So let's go to the details of what it might require. So title verification. Now, on the face of it, I'm sure that people who are looking across the border find that this may not be such an issue, but it is, because you have a tremendous line of land owning. So you have owners right across. So you might have 5 to 6 different lines, more than that, which you need to verify in order to ensure that your title has been perfected. And therefore, the importance of judging the present owner of the property as much as the earlier owner, so that the chain is complete. And I must mention, Nupur, here that in particular, you talk about agricultural land holding, for example. That is something which requires even a higher verification, because you require land revenue records and verification of the same. The next question would be whether, in fact, the current owner's right is transferable, and whether he has a perfect right to transfer the title, because obviously if the current owner's right is not perfect, it cannot be transferred over legally and validly. And of course, our concern would be to have a complete title on payment of so much money as far as the bargain is concerned. So firstly, whether there is a right, and secondly, whether the right is transferable. This you say because you have in India, as much as you might have in some other countries, you have leasehold rights, which means that you are under a lease from the government, and therefore you require prior permission from the government or any other authority. You require, in cases of tenancy rights, you might have tenancy rights which you're seeking to transfer. You might have land allotted by state governments and central government under various enactments. There are too many for me to even try to delve into those, but there are such situations. And then you have absolute ownership, of course, where there is freehold and you can transfer the same right absolutely and forever. The derivation of ownership. How do you derive ownership when you're buying? As a home buyer, as a person who's engaging in a real estate transaction, how do I buy? Now, on the face, it seems simple. But looking at this slide, if you come to derivation of ownership, which is the third point here, I've done the first broad two. I'll come back to maybe one or two later. But derivation of ownership, how do I derive my rights which I transfer to the person who's purchasing? So first you have, of course, an outright purchase, which is by a registered sale deed and title documents, which all need to be ascertained, as we talked about earlier. Second rights, and this is very common in India, is inheritance. We have large-scale inheritance devolution of property. So you might have that by way of intestate, which means when a person dies without leaving a will, and the property stands transferred to his or her heirs, and it is extremely complex, if I might say so, and you would definitely need lawyers, Nupur. So you need to ascertain that. Yes. And very often, of course, it is embedded with some kind of litigation, but I won't go there. The second method of devolution in inheritance, of course, is testamentary. I might add, even at the cost of opening up some avenues of discussion and disputes, that most testamentary dispositions also tend to be disputed and disputed over a considerable length of time. So even that is a process which not only the inheritance rights, but whether in fact they are under any contest is something that should be ascertained before the title and the devolution of ownership comes. The third would be something by way of partition. Now in India, as you do know, you have number of associations, which is either by way of a family property and joint family property. I'll just call it for the time being and hope for any further queries later, which get devolved and divided by means of partition. So you need to have the partition deed, the restrictions in the partition deed, or the conditions that might be there. You also could have partition arising out of partnership properties. So therefore, you have a number of situations where you could have partitions being affected. So the exact nature of demarcation, the exact amount of right in the land in question, and of course, the restrictions in the concerned documents is something which requires due diligence on. The next method would be gift. So you have a registered gift deed, you do require that. And the conditions again and restrictions in the gift deed is another factor that needs to be taken into account. Finally, the perpetual lease. If you have a perpetual lease, what rights you have within that, what rights you have to transfer. Sometimes the lease is non-transferable. So in that case, there cannot be any derivation of ownership from such a perpetual lease. So the rights of the lessor, so to say, under the perpetual lease deed have to be considered. The next point I would go to is the legality of construction. I'll come to this a little later, Nupur. So we'll just go back to the last slide. I'm just taking the points from there. The legality of construction. Now, this is again a huge thing, and I've seen times I'll share with you where, in fact, when properties or land itself was not regularized, and you build properties over them, the contention was that you could build anything, even more than what the laws permitted in regularized areas. Now, that's an anomaly, but those times are yesteryears, and today, the extent of construction, because in fact, we've had position where earlier you had limited rights of construction to the extent the area concerned. But the area has been gradually and very firmly widened up, permitting far more construction that was earlier permissible, which gives builders a lot more margins. But you do need to be sure, and this is one factor which is very, very important again, is that you need to ascertain when you're going into purchase a place as a home buyer or as a person who's purchasing a commercial property, to ascertain that the construction is legal. If it is not, the kind of impediments that can visit you, I'm afraid, is something that can be very damaging. The next would be government approvals, and I don't think we need to say much on that, where government approvals and authorizations are required. If you don't obtain the same, obviously, you are in the doldrums as far as the situation is concerned. We do need to do that. Next is acquisition process, and that would be true of India again, particularly because a number of lands are under acquisition. So the government acquires them for the benefit of particular agencies, and those agencies in turn develop the lands concerned. So you do need to ascertain the acquisition process. And I can mention to you, in fact, one of the projects where there was tremendous difficulty in Noida, which is a part of the NCR, of the greater point of India, Delhi, where in fact the farmers whose lands were acquired challenged the acquisition, and ultimately the acquisition was set aside. Of course, a higher compensation was awarded. So it is a feature which needs to be taken account of by developers and promoters in a very big way, as much as the people who are purchasing, because in the event of a setback, particularly in the litigation, it can prove to be a negative. The advisability on the last part, that is the publication, it is highly recommended, even though it may not be compulsory, that proposals should be advertised by ways of publication so that people have an opportunity to have notice of the proposed transaction, and that could give people right to A, object, B, bring to knowledge any issue that would be sustaining itself, and therefore, of course, help the entire process of making it a complete due diligent free, so to say. Let's go next now, Nupur, to the Real Estate Act. Thank you for having that ahead. And I think this was so much in the coming. In fact, we were missing this tremendously. And prior to this, the real estate sector was suffering major setbacks because of lack of regulator, lack of transparency, lack of accountability. And during the course from 2014 in particular, I'm mentioning, because this came during Modi ji's regime, which came into power in 2014. And we were seeing people struggling because their rights could not be secured. And they suffered setbacks not only in terms of timely, non-timely handing over of projects or the complexes in question to the people who had purchased them. But in addition, what you found was that developers and promoters were actually having a heyday. So one project would be started, the monies would be diverted to another project, and therefore each of the projects remained incomplete. Now, this was the pre-2016 era. So I'm making that clear. We are now in 2021. And we are talking about the good days that we do have ahead of us. And most of it is due to the RERA, as it is called, the Real Estate Act 2016, which has brought into forefront the entire potential, the object of the act being, of course, to increase investment, to protect the buyers, to regulate developers. I'm afraid if we're looking only at one sector, we are not. We're looking at the overall impetus to be granted to the real estate sector, which means regulate developers even more than the home buyers, to bring transparency into the real estate transactions, and of course, finally, most importantly, to increase the credibility. Because I think the sector, any sector which needs to develop or is developing or has developed, would need to have credibility in order to foster people to bring in more investment and to make it more booming, as we might say. And as I said, the way the sector is running right now, approximately 11% of the Indian GDP comes from the real estate sector. And there is, in fact, a demand while we speak that the real estate sector should have its own ministry so that it can be dealt with under a different umbrella and therefore bring higher surface onto this transaction. But those are, of course, certain demands and certain considerations. We can't vouchsafe for all of them. But they are serious thoughts and serious considerations which applies. The Real Estate Act applies mostly to all kinds of large constructions and large projects, so therefore excludes only something under 500 square meters, which apartments which are proposed to be developed are under 8. That is another exception. Where completion certificate has been obtained prior to the act, which of course today is a more or less a redundant kind of situation, but yesterday it is excluded from the act. And then you have, of course, renovation, repair, and redevelopment. Now, the reason this was left out was and excluded was that this doesn't involve publicizing. Now, this is a question of knowledge. So therefore, where people, purchasers, are not misled, in that situation, maybe the contemplation is and was that you did not need to bring it within the purview of the act. That is where the circumference of that particular situation was. What does it require and the rights of property buyers? I would like to, this is the act, and so therefore what you need to know is the rights of property buyers. You have complete information about the sale. Now, yesteryears you didn't. There was no requirement for disclosure aside from the normal commercial viability of the project and that you needed to demonstrate yourself. You have knowledge of the state-wise schedule of the project, how much has been completed. You can make a complaint about delay in possession. One of the major issues that has been confronting confronting us in a major way till now, till the act came into being, the claim, the refund of the amount in case of delay or in case of cancellation, and the compensation as required, and to receive and inspect the necessary documents and plans. I have seen, Nupur, several people, several thousands of people actually struggling to have inspection of their documents, particularly when agreements are entered. And therefore, the right to inspect itself and to ascertain and have the due diligence is something which puts the entire process into operation. The other contours of the Act, if you can go to the next slide, this may seem again to some of our viewers as different from the usual requirements, but in fact, this was again a very contested position on how to measure the area available to a buyer. So that's why now you have the entire method of calculation. I remember doing a case almost 25 years back, arguing about the method of calculation of the area available, which went from carpet area to super area and to several other concepts. So therefore, the definition and the method of calculation brings a finite situation to the entire position. Advance payment, another area of extremely gray dispute, if I might say, because a large percentage was taken in advance. So there is a limitation on how much you can take as a developer or a builder. So you can only take 10%, which means that ultimately there is a premium on the monies taken and the accountability to put the same A in the project, and B, not to divert it in any manner. The rate of interest in default, it's a common rate of interest which has been prescribed, which makes it even and equity based. To reduce the risk of builder insolvency. Now, this is an extremely imperative that has come across, because you can't use more the funds from one project to another. Now, this came in, I don't know if some of you followed in some of the litigations that happened in yesteryears, which is with JP and others, which has today come to some kind of resolution, because we've also started adopting the IBC and the government has also put in NBCC ahead. So NBCC is taken off the project, and we are hoping that the entire process will be completed. And 70% be deposited in different accounts. So this secures your rights, because then projects get completed as individual projects without shifting the funds over from one to the other. Extension position in terms of time is something again contemplated only twice. Otherwise, yesteryears, it could have been forever. Therefore, you bring a finality and again a finite position to this extension position. Can we go to the next slide? We have the authority. So the authority really is a regulatory authority as much as a adjudicating authority, and has tremendous powers. So you require registration with the authority, and if you don't get registered, there are methods to ensure that you do. And the reason for registration is again transparency and accountability. You have an adjudicating machinery for which addresses speedy dispute redressal, and the applications are required to be mandated in a time-bound period of 120 days. The very apt position of single window system is something again that I think we've been looking for, because we found that appraisals over different authorities cost a lot of time and delay in this entire process. Amicable resolution of disputes, of course, that's always something that we all look forward to, and the ADRs are something which goes forward. The authority has a right to advise the government in matters of development, and of course, being a specialist body, it gives a lot of margin. There is a tribunal which has been, of course, okay, this possibly could come later, but there is I'll just mention this for the time being. From RERA, sure. There is an appellate tribunal which has been given all the powers to redress again in the event the authority is unable to resolve, or one has a grievance against what the authorities have. Could we go to the next slide, Nupur?
Sure.
Which compliances are to be met? Now, this is where I think the real rub lies in a good way, which means that you have the real estate project registered. These are the compliances that need to be done by the developers. You need to upload the agreement, the plan, the approval, all on the RERA site, which makes it available to not only the authority, but to all that need to survey it. The updating of this with various revisions separate bank accounts for 70% of receipts for each project. I think this lends to a lot of financial credibility as much as anything else. Approvals and insurance under various state laws, and of course you know that we do have a large number of state laws which regulate activity, and finally the timely completion and delivery, particularly of the common areas. I think the common areas have a tremendous interest as much as the individual numbers in question. Could we go to the next slide, Nupur? So the landmark judgments, we've had some which deal with the issues in question, which the first one being, I'm just going to the second, in fact, the Pioneer. This actually put the home buyers in a position of financial creditors. And I think this raised the complete situation as far as land buyers were concerned, because it made them into a position where they were given equal and importance under the Insolvency Act, which in fact came around essentially on account of a real estate project, by the way. So it was a very happy event that put home buyers in this capacity. Bikram, the IREO Grace, the first judgment that is mentioned here, this in fact held that incorporation of one-sided and unreasonable clauses is an unfair trade practice. Now, we've had various situations where the builders have a monopoly and therefore would dictate the terms. So to have a position where you do have restrictive trade practices and unfair trade practices being able to be set aside is something I think would give all the land buyers and home buyers an edge in the entire transactions. The Bikram Chatterjee itself is, of course, a case where the NBCC, which I've had occasion to, and I've been in this matter, dealt with the construction of a large number of residential units in Noida and Greater Noida. And they were able to be put out of the misery as far as the home buyers are concerned because of NBCC's intervention, which incidentally it has done in a number of scores. So with these kind of cases, and in fact, not one more case which was not mentioned here, and I'll just mention this on the last front, is a case which dealt with the fact that in addition to relief under the RERA, you could also seek remedies under the Consumer Protection Act. Now, Consumer Protection Act is also something which has come in India as a precursor and as a landmark situation to ensure that home buyers and people who are affected have a reasonable, expeditious remedy to avail in the event of defaults. And that has been, of course, a source of immense redressal mechanism for the people. So therefore, this judgment which upholds rights not only under one act, but under the other act, being the Consumer Protection Act, is something which has again led to a high credibility issue in the real estate sector. With this, Nupur, I think I would just like to mention, as I did in the first part, that we are now looking forward to further issues on investments. There are questions on GST waiver, not only for COVID, but for also lending to higher investment in the real estate sector. You're looking at a lower loan rate transaction for home buyers, which is also one of the demands that the sector has been leading to and something which is under consideration. So we are hoping that with the boom in the real estate sector, of course, with a slight setback, if I might say so, under COVID times, nonetheless, the sector remains essentially a booming sector and has the potential to bring forward a lot of relief and a lot of avenues for all the countries concerned who are here with us today. And therefore, we look forward to this close association and ensure that the world progresses with us progressing in the real estate sector. So with this, thank you so much.
Thank you.
Thank you, ma'am. Thank you, ma'am. That was quite an insight on the entire act and the few judgments that you have led, and to do with due diligence, why it is important and how it actually should be taken care of, and how a consumer can actually protect his interests. So that was a big overview that our viewers could get from you, and from a person like you, where you have actually been a part of a lot of these cases and handled them yourself. So thank you so much, ma'am, once again for taking out time on this webinar. I'm sure it has led a lot of information for our viewers.
No, Nupur, in just a short period of time, ma'am has summarized the entire structure of real estate due diligence and the laws and provisions applicable around it, and what benefits the investors, and what could be of interest to investors. Everything has been summarized in this short conversation.
Absolutely.
Nupur, if you can just take this forward, please.
Sure. So in addition to I'll start from where ma'am left. I would actually just go back and, lay stress on why and how RERA can actually be helpful for a consumer. So, what exactly we kind of find out in when we actually file complaints. So how is it a benefit? Why this forum should actually be adopted to by a consumer or by a lottee or by a promoter or a real estate agent. So that's where I would like to press my discussion on. So there is in this act, the section which actually allows you for a refund or a compensation or a return or a cancellation of the allotment of the project that you have done, and that is basically revolves around section 18. So most of our viewers would after the overview that ma'am has given, they would like to know exactly what will this authority provide me if I go for a case over there, or why I should adopt RERA over any other forum. So the answer to that is that the section 18 of the RERA Act actually provides for a refund or a compensation or a cancellation of the allotment done under RERA, a project which is booked by a buyer under RERA. So it actually, in 3 scenarios, it allows a promoter to refund the amount which has already been paid by the allottee, or return the amount, refund, pay compensation, and interest on whatever the amount which has already been paid. So these are 3 or 4 powers which RERA as an authority allows. The scenarios where it allows is where actually, the promoter fails to discharge any of the obligations under the act or the rules made thereunder. There is the second scenario is where the promoter's title in the property is defective. So where the property, like ma'am said, that if the first title is not clear, obviously the second title, which is passing on to a owner or an allottee, will never be clear. So in that scenario also, this section allows a buyer or a allottee to seek refund or a compensation. And last but not the least and most important is where actually the promoter fails to give possession of an apartment or a plot or a building in 2 scenarios, where either it is not in accordance with the date which is mentioned in the agreement to sale. So let's suppose there is a sale agreement which has been done, and the project was registered with RERA in 2018, and the sale agreement mentions that the project is going to be delivered in 2020. But whereas the project is not delivered in 2020, then thereafter the powers under RERA allow that they can actually allow the allottee can actually seek refund or interest and a compensation, all 3 of these things of that allotment. So that is basically when he does not meet the allowable date that he has agreed to give permission on. Now, going forward, I would just like to add to this is that, there are 2 times that a promoter can actually seek extension of any project. So there are only 2 times that RERA under the Act, he's allowed to seek an extension. So let's suppose, going back to the example that I took, if there is a project which is, rolled out in 2018 and he gets registered with RERA, in the sale agreement, he says that he's going to deliver that project in 2020. In case of whatever reasons he's not able to, deliver it in that period of time, he can actually seek one extension, thereafter seek another extension. However, there have been cases where we have found out that innumerable delays have happened, and whatever the date is mentioned in the agreement to sale, that has actually been taken into consideration, and refunds or compensations or interests have been allotted by the authority. The other scenario, the other part where the promoter fails to give possession could be where there is a discontinuation of his business due to suspension or revocation of his registration under RERA. Now, if there is a registration that he has taken, but there is a suspension or there is a revocation, if he withdraws his registration, in that scenario also, the promoter is required to pay a refund or a compensation and interest along with the refund in the scenario. Now, the other thing that I wanted to also mention here is that, when a compensation is sought, a compensation or an interest, our viewers would like to know whether on what rate am I going to get, or what rate is RERA going to allow. So there have been various judgments which actually vary. Normally it goes by the SBI lending rate, but we have had cases, we've had tenures where, it has been a lot. I mean, the compensation or the interest has been allotted up to 10 or 12%. It goes up to 18% also, but ultimately it is under the jurisdiction of the members and the chairperson, whoever is actually dealing with the case. So that's broadly about what Section 18 allows you, and why a consumer or an allottee should actually opt for RERA as an authority for their disputes. These are the reasons that, you can actually go ahead, if you don't want a project, you can actually go ahead and seek a refund, ask for an interest on the amount which is already paid, and also ask for a compensation. So we generally, earlier, like ma'am had mentioned that, earlier, this is pre-RERA regime, when we actually did not have this act, and buyers were actually moving around pillar to post for their delayed possession, or for interest, or for a compensation. They were actually either going to the consumer forums or any other forum. But with this forum, and with timelines set, like we have mentioned that there are timelines set for taking a case up to a board. So this is something which has actually changed the entire scenario in real estate. And actually, this would be more from the consumer perspective, where actually a consumer has the right being given under this particular act. So that's from my side, where I actually wanted to press more upon why the body, why the authority, or why opt for a compensation or an interest or a refund under this authority than any other forum. So that's from my side. That's the takeaway from my side. In addition to what ma'am has given, and Farhat had to say on UAE, I would request Farhat to take over for a question answer session now. Farhat?
Yes, thank you, Nupur. Thank you, Dr. Anand. I really appreciate, such an insightful information that has been shared with us. Sorry, I was on mute when I spoke earlier. So to the audience, in case we have any question and answers for your investments, you're worried that, what would happen for amounts paid by you 2 years ago, 3 years ago, and your real estate investments have not been delivered, what legal remedies you may have. If you may please put your questions here, and if anybody from the team can send me, then we'll be more than happy to answer that.
I think prior to the start of the webinar, during the registrations, we had one question from one of the government officials in RERA, I think, where they have put a very, very nice and a very interesting question. So if I may take that up.
Yes, please.
So the question actually was put up was, can only a aggrieved person have option to complain? It further says, can a sub-registrar take note of a violation and impose a penalty or file a case before RERA? So I find this question very interesting. I would rather, want to go back more on the definitions in RERA. Now, incidentally, the Act does not define an aggrieved person. The Act defines only a person. And this comes from Section 31, which actually, says, and any aggrieved person may file a complaint with authority for any violation or contravention of provisions of this Act or rules against any promoter, agent, or allottee. Now, my take or my interpretation to this is that an aggrieved person can be, the inference for an aggrieved person I would draw from Supreme Court's judgment in Jashbhai Motibhai Desai, which was actually delivered in 1975, wherein the Supreme Court has actually derived a test of an aggrieved person. It has actually very clearly explained what an aggrieved person is. So deriving my interpretation from there, my answer to this would be yes, a sub-registrar has and can file a complaint as an aggrieved person for any kind of violation that he or she finds in any of the RERA applications or the registrations or anything which comes under the purview of RERA. So that's where I would like to draw this inference on, keeping aggrieved person's definition deriving from this judgment, and implying on the section which actually talks about not the person but talks about an aggrieved person. So it's a very interesting question that I found, and I thought I'll take this up. I hope we have the participant as an attendee on this show, and I've been able to make justice to his answer. Nevertheless, we will have we can have this question taken up on a side and have it answered separately as well. But I hope this is the answer that would satisfy them.
Thank you. That clarifies. I believe Nupur, it clarifies. So we have one more question.
Sure.
Where Mr. Devdar is asking that large townships, and this we know particularly in the NCR region, are basically a 99-year lease. So would it be considered as a freehold or a so why is it that it is a 99-year-old lease? Yes,
would you
Dr.
like me to?
Yes, Dr. Anand,
Please.
Well, a lease is a lease, whether it's 99 years or anything lesser. The point is, leasehold rights come from the definition and the method of the document. So until it is converted, and it can be converted into freehold, there is a process. In fact, the freehold came into during our horizon, so to say. So we actually saw the transition to that period. So therefore, whether it's 99 or otherwise, it will remain leasehold unless converted into a freehold, which it would be.
And I think the rights to renew will always remain with the lessee upon expiry of this 99-year period, ma'am?
No, I'm not sure of that. That I think depends on the terms. It does vary. Offhand, okay. I would not be able to respond to that. No.
Okay, ma'am. Okay. So, but then 99 years is certainly a very, very long period to have ownership of
time. Yeah.
It's a couple of lifetimes.
Yes, of course. And with pandemic, I mean, so things have been so uncertain. Unfortunately, very difficult phase for every sector. So there is one question: is there any time limit to file a complaint? Yes, there are limitations as per the Limitation Act. But then I think that is sufficient. I think it should be 12 years, Nupur.
Yes.
12 years is the limitation that we have for filing a complaint under RERA.
RERA, yeah.
Right. So enough time.
There is a defective title that it is not barred by limitation. Like I said, that if there is a title of the promoter which is defective, in that case, the Act itself provides that there is it is not barred by limitation.
Okay. This is a question, interesting one, and I'll put it to Dr. Anand, and I'll just take one more question after this question. So whether this Act, RERA Act, is now applicable to Jammu and Kashmir also?
By and large, all acts that have come, because now Jammu and Kashmir becomes an integral part of India, which it always was, by virtue of the abrogation of Article 370. Specifically, I'll be honest, I have not looked at the response in terms of the legality of it. But by very nature, all the acts that apply in India, unless otherwise specially excluded, would apply to Jammu and Kashmir.
Yes. So there is a special schedule that has been put in the particularly for the land related laws, but we don't know whether the RERA, but more or less the regulatory laws will I believe we should apply.
Yes, as I said, I would reserve my comments till I have specifically seen it, but otherwise, yes, in a broad principle, yes.
Yes, ma'am. Yes. So, so there is one. What happens when due diligence process? No, this is the last question that we have. So, what happens when the due diligence process reveals fraud or a form of illegality? So, ma'am, the question I understand here is that if somebody has been defrauded by a builder, so can we take police action, criminal complaint, etc. be initiated?
Always. The criminal law is independent of the civil remedies that have been made available under RERA. Or the Consumer Protection Act. But in fact, even the RERA has certain penalties and imprisonment within the scope. But having said that, the remedy for any criminal action, fraud or cheating or any other action is something which is always available under the regular penal code, and you can go to the police or the court as a situation may be.
As the PS, and just for if there any legal or non-legal person here, so there is one very famous judgment also, ma'am, Lalbani Devi versus State of Bihar of 2006, where it has been clarified that a criminal proceeding will have its own independent nature.
Always has. That is the nature of civil and criminal remedies as defined in the country and in most jurisdictions.
So here we end the question and answers. I mean, we could have taken more, but then we have limited time, and we are so lucky to get your time at such a short notice.
Well, a pleasure, and I look forward to further interaction, Farhad and Nupur. It's really
Thank you,
been a
ma'am.
great time. And as I said, I wish it could have been across surface, but for the time being, so be it.
This is the new norm format and platform that we have that we have applied to our lives.
Yes.
So thank you, ma'am. Appreciate, and I look forward to see you when I'm in Delhi very soon, inshallah, and we'll definitely take this forward.
Inshallah, very soon.
Thank you, ma'am. Thank you.
Ma'am. Thank you so much.
Thank you, audience. Thank you, Nupur. Thank you, Dr. Anand. Thank you, Team CMI, for making this event successful. So this is about CMI. Yeah. So this is about CMI. What we do, we have an office here in Dubai, and we just started our office in Delhi, and look forward to have more offices across. Thank you. Thank you, everybody.
Thank you.
We'll end this now. Thank you.
Thank you.
Bye, ma'am.
Bye-bye.